Hello, everyone. This is David H2. I'm going to go over the Bill of Rights and, well, the amendments, basically. Bill of Rights, and they will be displayed on the screen, what the Bill of what they are. I'll be referencing the Penguin Guide to the Constitution, United States Constitution, a fully annotated Declaration of Independence, United States Constitution and amendments, sections from Federalist paper. Okay. The framers of the original Constitution assumed that it was not necessary to include a Bill of Rights in their proposal plan for the Union. The ostensible reason for the omission was that most of the state constitutions already passed bills of rights. Therefore, the inclusion of a Bill of Rights in the federal Constitution would be redundant. Another more compelling reason may have been that when the idea of the Bill of Rights was raised in September by Virginia Delegate George Mason, the members of the convention, tired and desperate to return home, feared the debate on the subject might extend their stay in Philadelphia by many weeks, if not months. The omission of the Bill of Rights proved to be both tactical and a strategic error. When the Constitution was submitted to the states for ratification, many of the critics of the Constitution pointed to the absence of a Bill of Rights as a fatal flaw in the document. As consequence, the further supporters of the Constitution who called themselves Federalists came forward and with promise to make the draft of a Bill of Rights the first term item in business when they knew Congress convened after the ratification of the Constitution on September 25th, 1789. Congress presented to the states 12 amendments, 10 of which received the necessary approval of three-quarters of the states on the document December 15th, 1791. It is those 10 amendments that were commonly referred to as the Bill of Rights. One of the two amendments not approved dealing with the congressional representation has not proved of any significance in the operation of the Constitution. The other deals with congressional salaries was eventually incorporated into the 27th Amendment. Amendment 1, Freedom's Petition and Assembly. Congress shall make no laws respecting and establishing a religion or prohibiting the free access thereof, or abridging the freedom of speech or of the press or the rights of the people peaceably to assemble and to petition the government for redress and grievance. Okay, First Amendment is remarkably brief considering the breadth of the protections that it provided. This section of the amendment provides Congress for making any laws respecting the establishment of religion is the cornerstone of the American notion of separation of church and state and guarantee of the free exercise of religion has proven a powerful means by which people have been allowed to express their religious beliefs without fear of government reprisal. Similarly, the guarantee of freedom of speech, of the press, and of the right for people to peacefully assemble, as well as the right to petition their government, and by implication, to protest the actions of the government, are at the heart of the American Constitution definition of liberty. The freedom have, however, been subject to restrictions until the early 12th century. The First Amendment applied only to the action of the federal government. State governments were free to pass their own laws, contraving some of the provisions of the First Amendment. For example, the state of Massachusetts continued to accord congregational church special privilege and did not move to explicitly separate church and state until 1833. Moreover, throughout the 19th century and some of it into the 12th century, state government have enacted laws by placing restrictions on speech, freedom of press, and on the certain forms of public assembly. It has only it was only in the 12th century. Oh, it was only in the 20th century through application of the incorporation doctrine that the 14th Amendment guarantees the states must not abridge the privilege or immunities of citizens of the United States, nor deny citizenship equal protection of the law, begin to obligate state governments to guarantee their residents the same freedoms as those articulated in the First Amendment. The exercise extent of the guarantees of the First Amendment continues to be subject to contention. Oliver Wendell Holmes in the Supreme Court opinion, Sheknick v. United States, 1919, made the common sense argument that the guarantees of free speech do not extend to the right to shout, fire in a theater, and cause a panic, which no such danger actually existed. Governments have often asserted the right to regulate public assembly and protest in order to ensure public safety. Similarly, the wall of separation between church and state is not impenetrable. The United States Congress continues to employ a chaplain, and the Word of God is frequently invoked at many of the official government gatherings. The federal courts are frequently presented with cases such as the legitimate litigants claim that public displays of religion beliefs, e.g., the display of the nativity scene in a public square at Christmas time, violate the principal separation of church and state. Thus far, there is no clear resolution of where the boundary between a religion and civic display lies. I would recommend you go and listen to Attorney Di. You can find her on YouTube and Substack. I think she's on Substack. Well, she YouTube and TikTok, and that is at the @ attorney, ATTORNEY, attorney _DI, Attorney Di. Yeah. Thank you. And Amendment 2, a well-regulated militia being necessary to the security of the free states in the right of the people to keep and bear arms shall not be infringed. Second Amendment contains two parts, a preface, which states that a well-regulated militia, meaning citizens' army authorized by the state, is a necessary and desirable thing, and the operative section of the amendment, which asserts the right to the people to keep and bear arms. Constitutional scholars have argued voraciously about whether the comma separates those two parts signifies the right to keep and bear arms without state interference is confined to the use of such firearms in conjunction with one's duty as part of the government sanctioned militia or army, or whether there is an individual to right to keep and bear arms under any circumstances. The most recent ruling of the Supreme Court, District of Columbia v. Heller, 2008, suggests that the Second Amendment does guarantee an individual as well as a collective right to bear arms. But the courts also conceded that there are some instances, e.g., regulated for the sales of assault rifles, which the local states and federal government do have the right to regulate the sale, use of arms. Like many aspects of the Constitution, the meaning of the Second Amendment is subject to varying interpretation. Yes, it is. Because it reads, a well-organized militia, comma, being necessary to the security of a free state, and comma, the right of people to keep and bear arms, comma, shall not be infringed. So is it all one thought or is it multiple thoughts? That's the controversy that's been going on forever. Amendment 3. And I'm referring to it article because the original Constitution called these articles, not amendments. Amendment 3. No soldier shall in time of peace be quartered in any home without the consent of the owner, nor in a time of war, but in the manner to be prescribed by law. This amendment, which has lost much of its immediacy over the course of time, was considered of pressing importance by the members of the First Congress, who drafted it because attempts to force Americans to provide lodging for British troops whom they considered to be hostile occupiers of their land. Wow, that's rich. During the years leading to the Revolution, where an important cause of the Revolution, the amendment does, in a manner to be prescribed by law, allow for the government to use private homes to provide lodging for its own soldiers in a time of war. More generally, the Third Amendment has, with the Fourth and Fifth Amendment and Ninth Amendments, been interpreted to imply another right not explicitly mentioned in the Constitution, the right of privacy. That's an important one. Okay. Amendment 4. The right of the people to secure in their possession houses, papers, and effects against unreasonable search and seizure shall not be violated, and no warrant shall issue, but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or thing to be seized. The guarantee against unreasonable search and seizure of a person's house and property, and the insistence that any such search is based upon probable cause and accompanied by search warrants were another product of the Americans' experience during the Revolution, when British customs officers and soldiers carried out blanket searches and seizures without proper warrants. In recent years, though, through use of the incorporation doctrine, the Fourth Amendment has been interpreted to mean police officers and all levels of government must demonstrate probable cause before stopping and searching anyone whom they might suspect as of a crime. The precise definition of probable cause has been much debated, and in many cases, police officers are forced to make a difficult judgment about whether they should detain an individual and search his or her possessions in any age in which advances in technologies have offered the government new ways to gather evidence of possible crime, i.e., wiretapping and other means of sophisticated electronic surveillance. The federal courts have been presented with new dilemmas about how to interpret the provision of the Fourth Amendment enactment of the Patriot Act in the aftermath of the 9/11 attacks 2001 has significantly expanded the government's ability to carry out such surveillance. Amendment 5. The Fifth Amendment, and this is the one people may take, was 1791. I think the first ones are 1791. This was ratified in 1791. No person shall be held to answer for capital or otherwise infamous crime unless on a presentment of indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in a time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without the just compensation. Reflecting long-standing tradition of English common law, as well as American perception that the British had violated those traditions in the years leading up to the American Revolution, the Fifth Amendment requires the people charged with capital crimes, i.e., serious crimes that falls under the jurisdiction of the federal courts, be the first presented before a grand jury, a group of ordinary citizens drawn from the general population. Those serving in the military are not afforded the protection. They are to be tried in a military court, which set their own rules, judicial procedures. Although indictment of grand jury is standard practice in important civil and criminal proceedings at the federal level, many states have not used the mechanism for securing indictments of accused excuse me. I got that. Maybe I lose my place. Okay. The provisions of the Fifth Amendment preventing double jeopardy and stipulates that individuals cannot be tried for the same crime more than once. If the defendant is acquitted of a crime, the government does not have the right to prosecute the individual again. And if defendant is convicted, the government may not impose multiple punishments for the same crime. The phrase "taking the fifth" refers to the provision of the Fifth Amendment ensuring the right against self-incrimination, the right to refuse and to answer questions in a court that might lead either to indictment or punishment of the alleged crime. Finally, the Fifth Amendment contains a very open-minded guarantee echoing the words of the preamble, the Declaration of Independence, that no person can be deprived of fundamental rights of life, liberty, and property without due process. The concern for protecting the property is further emphasized in the prohibition of taking private property for public use without just compensation. In fact, federal and state governments often take control of property, for example, for the purpose of building a highway or some other necessary public works. By using the doctrine of eminent domain, in those cases, owners are compensated for the value of their property, although in many cases without significant litigation. Amendment 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of state and district wherein the crime shall have been previously ascertained by law committed, which district, and to be informed of the nature of the cause of the accusation, to be confronted with the witness against him, to have compulsory process for obtaining witnesses in his favor, and to have assistance of counsel for his definite defense. Centerpiece of American criminal justice system. The Sixth Amendment is appropriately considered in addition to guaranteeing all criminals defendants a trial by jury. It provides an outline of the basic procedures to be followed in such trials. The trial shall be a speedy one, which is to say, accused criminals cannot be imprisoned for lengthy periods of time before receiving a trial. The trial must be public. The framers of the Sixth Amendment specifically reject the format of English Star Chamber proceedings, that is, proceedings held in private, away from scrutiny by the public. The juries in the criminal trials should, in normal instances, be drawn from ordinary citizens who are residents in the state and region where the crime was committed, although in usual cases, if the crime is of such sensational nature that the trial might be held to impanel an impartial jury, it might prove impossible to have in a jurisdiction other than the one which the crime was committed. The Sixth Amendment also guarantees to the accused the right to be confronted with the nature of the charges brought against him, the right to confront either directly or through an attorney the witness against him, and the right to present witnesses in his defense. Finally, criminal defendants are entitled to assistance of counsel, that is, the competent attorney to assist them in their defense. These basic guarantees have been elaborated in countless court cases in the more than 200 years since the amendments were ratified, and through the incorporation doctrine have become the standard procedure for criminal law trials in the states and other locations, as well as in federal court. That was Amendment 6. Amendment 7. In suits, common law, where the value in controversy shall exceed $20, the right of trial by a jury shall be preserved, and no fact tried by the jury shall be otherwise examined in any court of the United States than accused according to the rules of the common law. That's more than a mouthful when you're talking to an attorney, because what is common law? The Seventh Amendment provides guarantees similar to those in the Sixth with respects to civil suits, although it does limit the right of trial by jury to suits in which they're involved. The terms and extent of the application of this amendment, substantial sums of money, have been worked out through a myriad of cases involving plaintiffs, the person bringing the suit, and the defendants, the person being sued. For example, while the standard for conviction in a criminal trial is jury's unanimous verdict, criminal that the accused is guilty beyond a reasonable doubt, a jury in a civil case may award damages to a plaintiff if a majority of the juries find a preponderance of the evidence on his or her behalf. The incorporation doctrine has not been applied to this amendment, and for the present, civil suits tried in states and local courts may follow different procedures than those as outlined in the Seventh Amendment. Eighth Amendment. Ooh, this is a short one, but very powerful. This is a very short amendment. Is excessive bail shall not be required, nor excessive fines imposed, nor cruel or an unusual punishment inflicted. Yes. The prohibition against excessive bail, a sum of money put up to gain release for prison while awaiting trial and in return if and when the accused appears for trial, is a reflection of the belief that an accused criminal is presumed innocent until found guilty. The definition of excessive bail is a substantive one, but the intent of the amendment is to demand a sum of money sufficient to guarantee that the accused does show up for trial, but not so high as to make it impossible for the accused to gain a release. The prohibition of excessive fines is intended to assure the punishment fits the crime if it is closely connected to in its rationale with the final section of the amendment that guarantees against cruel and unusual punishment. Again, drawing on English common law traditions, Americans were seeking to move away from ancient practices of gruesome punishments for relative minor offenses. The definition of cruel and unusual punishment has often proven a point of contention. Currently, opponents of the death penalty argue that the punishment qualifies as cruel and unusual punishment, except for the period during the 1970s. The Supreme Court has not agreed and brought both state governments and federal governments are free to permit execution if they desire. At present, 35 of the 50 states have laws permitting death penalties in some cases, usually, but not exclusively for murder cases. Amendment 9. The enumeration in the Constitution of certain rights shall not be construed to deny or discourage others retained by that's a mouthful. Of course, all these were still ratified in 1791. This is Ninth Amendment. One of the reasons given for the framers' omission of the Bill of Rights for the original Constitution was the fear that if unintentionally failed to mention the fundamental rights in such a listing as those rights might be go protected. One of the reasons the framers of the omission of the Bill of Rights from the original Constitution was their fear that if they unintentionally failed to mention some fundamental rights in such a listing, those rights might go unprotected. The concern caused many of the delegates to fear any debates over Bill of Rights might drag on for weeks or months as they sought to cover every conceivable right. The Ninth Amendment makes it clear that the listing of rights mentioned in the Constitution and its amendments do not constitute all possible rights to which the people are entitled. Over the years, the courts have defined unenumerated rights, such as the right to vote, the right to move about freely, and perhaps most controversial, the right to privacy, including the right of women to have their control over their health and reproductive decisions. Yeah, that's the 10th Amendment. The powers not delegated to the United States by the Congress. Start over again. Amendment 10, ratified 1791, like all the rest of the first 10 bills, amendments. The powers not delegated to the United States by the Constitution, nor prohibit by it to the states, are reserved to the states respectively or to the people. When the Constitution was presented for ratification to the people of the 13 independent states, many were surprised or alarmed by the extent to the which the powers previously exercised by the states, for example, taxation and control over commerce, were now to be exercised by the federal government. In words of Virginia statesman Patrick Henry, the new government was not really federal in character, but rather a consolidated government. The 10th Amendment reserves all powers not specifically given by to the federal government by the Constitution, most of which are combined with Article 1, Section 8, and the enumeration of the powers to Congress. To the state governments, it was intended to ally fears about federal government possesses excessive powers. In one sense, the 10th Amendment is one of the most important features of the Constitution, for it articulates the principles that the federal government is one of specifically delegated powers, and that it should only exercise those powers explicitly enumerated in the Constitution in fact, the 10th Amendment, because of its generality, has not proven to be much of an impediment to the steady expansion of federal powers since the time of the Constitution was adopted, although opponents of the big government have in recent years invoked the 10th Amendment in their arguments with greater frequency. Yeah, that's the Bill of Rights. That's a quick rundown of it. It's kind of a definition by Penguin, so that's if you want to get that. That's who's running down that. I'm going to go over the rest of the amendments here in a little while, probably in another podcast. But right now, that's the first 10. That was what we started out with in 1791 to give us kind of a basis of what the Constitution was about. If you have any ideas, or if you have a disagreement with what I've read, you can put it in the comments. I would look into that. But this is what I've read from the opinion of the Penguin Guide, written by Richard Beeman. So Richard Beeman's the one who translated and put some of this in writing. And that's who I'm going off of. Being as I'm not a lawyer, I don't know the details of some of the stuff. So I depend on that and some of the stuff I've heard through lawyers on other apps. And thank you for your time. Like, share, follow. Please remember you are loved no matter what you do. And hey, I'll see you around on the social medias. Thank you. Bye.